Okay. You're live.
Good morning. This is Senate Judiciary. We are on March 29th, 2023, and we're taking up for the first time an act relating to civil and criminal procedures concerning legally protected healthcare activity. And Michelle Childs from Legislative Council, who's neither for or against, is here to walk us through the bill.
Sure. Good morning. So for the record, Michelle Childs, Office of Legislative Counsel, and I'm going to share my screen. And I'm actually going to start with S37, which the Senate just passed. And I'm doing that because you have probably heard, I think, from Senator Lyons talking about S37 on the floor, that S37 and H89 are intended to work together. So we might kind of casually refer to them as companion bills, but they're not companion bills in the traditional sense where we talk about like there's a Senate and a House version of the same exact language. These are just dealing with this similar issues, but the healthcare bill, S37, dealt with issues around insurance, the provision of insurance coverage for reproductive health care and gender affirming care services. It dealt with licensing of people who provide those services, those types of things. And this is more in the realm of court procedure and criminal and civil procedure. A couple of things I just wanted to note at the forefront is that this bill does not change in any way either the access to reproductive care or gender affirming care in Vermont, in the sense that it's not changing anything with regard to minors' access to those services or anything like that. It's firmly grounded in protecting the provision of those services here, patients and folks who would be receiving those services here from outside kind of extraterritorial application of other states' laws that are in conflict with Vermont's laws. So I just wanted to let you know it's not changing, because you know that we passed the constitutional amendment last November with regard to reproductive services. We also have language and statute around that. Similarly with gender affirming care services, there's no restrictions or bans that prevent people from accessing those services, so they're legally entitled to obtain those services. And this bill doesn't tinker with that at all. So I just kind of wanted to put that over to the side, because I know those questions tend to come up a lot in the discussion of this bill. So the reason I'm going to start with S37 is because there are definitions in both bills of creating 3 new terms for purposes of all of the Vermont code. And that would be for gender affirming healthcare services, reproductive healthcare services, and what is called legally protected healthcare. And when the Senate started working on S37, what they decided to do, and made sense when we were working on this piece in the House, was to take insurance out and reworked the definitions. And so the folks in this room were involved in that. I was involved with that, along with Jen Carby and Amarin and the healthcare committee. But the definitions need to be the same. They're creating the same definitions with the same statutory reference in Title I that applies throughout the code. So instead of using the older one that the House had done, because it had done it prior to S37 doing its work, I thought it'd be best to go with the definitions in S37. And so they are, we just needed to do some kind of logistical rewording to make it work around the health insurance issue, but the concepts are the same. So if you look at Section 1, so in Title I, under general construction of statutes, where we have like kind of that long list of certain terms that you might see throughout the code, and it defines them for purposes of the entire code instead of having to go and put that definition everywhere else. You'll see the definition of gender affirming healthcare services there, and I won't necessarily go through that. I think you can read that. But I will go through the next definition for legally protected healthcare activity. So on B1A, so the first one relates to folks exercising their right to obtain reproductive healthcare services or gender affirming healthcare services in the state of Vermont. So that pertains to someone trying to obtain those services. B1B is focused on folks who might be aiding or facilitating someone in obtaining their healthcare services. So if you look at that language starting on line 18, legally protected healthcare activity means any act or mission undertaken to aid or encourage any person in the exercise and enjoyment of rights to reproductive healthcare services or gender affirming healthcare services. So that could be a provider, it could be a pharmacist, it could be a volunteer at a clinic, it could be a family member who provides either financial resources or
Can I ask you a
transportation.
question before we even,
Sure.
I appreciate what you're doing. But in section 1, and I can't see the line number because there's no line numbers here. But down at the end of A, there's the statement, gender affirming healthcare services does not include conversion therapy as defined in 18 VSA 8351. But up above, it says gender affirming healthcare services means all supplies, care, and services of a medical, behavioral health, or mental health, surgical, psychiatric, therapeutic, blah, blah, blah. So how does that, what is defined in 18 VSA 8351 that is exempted from all that?
I would have to pull up the definition of conversion therapy, but the legislature banned conversion therapy, I think, for minors at least. That discussion took place in Senate Health and Welfare, but I can check with Ameren about, because the definition.
Well, I think it's important to understand why we're saying all what we say in A and then say there's an exception, but that exception doesn't exist elsewhere.
Elsewhere. Well, I think the general gist is that conversion therapy is not considered to be gender affirming. It's the opposite of that.
So I think some of that is just, I know that in the world, there has been some concern that conversion therapy could sort of be re-legitimized. And so I imagine, I know I certainly wasn't part of the conversation, but I imagine that is potentially why that is explicitly named here. And, you know, as someone who works with trans youth in my mental health practice, you know, there is a behavioral health and mental health aspect of supporting someone through that process. And that's my guess as to why those supports and services are named. Because I think a lot of times when we think about gender affirming care, we jump immediately towards medical intervention and surgical intervention and forget that there's a whole spectrum of ways of supporting people who are transgender and gender nonconforming.
So if you look at the definition in current law around what conversion therapy is, it means any practice that seeks to change an individual's sexual orientation or gender identity, including efforts to change behaviors or gender expression, etc. So gender affirming healthcare is not that. And I think that's I think just a plain language reading of the two would be clear about that, but the Attorney General's office just suggested that adding the clarification that conversion therapy is not considered gender affirming care.
Good. Well, going by the emails I've received. I'm sorry, I interfered with your train of thought.
That's okay. Okay, so I believe, so we were on legally protected healthcare activity. And so I was talking about in subdivision B1B, that's around facilitation. So somebody who's helping someone obtain care that is legal in this state. So moving on to the top of page 2. Oops, sorry. And I'll just note some elements of this that are important. The first one being that you're aiding someone in obtaining the health care. And then you look at the top of page 2. And the healthcare service is provided by a person who's licensed in Vermont, and that provider is physically present in Vermont, and they would be legally protected if the service is permitted in Vermont, regardless of the patient's location. So generally, when you're talking about where does the healthcare activity occur, that's where the patient is located. But for purposes of this, and we're talking about legally protected healthcare in these two particular areas, is it's regardless of the patient's location.
Okay, when you say regardless of the patient's location, are you talking about their origin, from what state they're currently a resident of, or?
It could be that, or it could be that they are at the time they receive service, that they are physically present in another state. So an example would be, let's say, if you had a Vermonter who was a college student in another state, and they have their mental health counselor is here in Vermont, and they need to be able to access their counselor and speak to their counselor. They're in crisis, so that as long as the counselor is licensed here in Vermont, providing within the scope of their practice here in Vermont, and the provider is physically present here, and the service they're providing is legal here in Vermont. The fact that Vermont student is located elsewhere at the time would then not negate the protections for the provider.
Oh, and that's an S37, not H89.
It is in both.
It's in both.
It's
Okay.
just more that we
Didn't see
had
it.
to kind of, the language in 89 for the definitions had the insurance provisions all through them. And when they really started digging into S37, it seemed we needed to kind of break it out into different subdivisions. So.
Thank you.
Yep. Okay, so moving on to the next one on subdivision C, that's where we broke out the provision of insurance. So it's the same kind of concept, is that the provision or issuance or use of insurance for reproductive health care services or gender affirming health care that's legal here in Vermont, is protected regardless if the insured is somewhere else. So let's say that college student is somewhere else, they're still protected. That insurance company for providing that insurance coverage is still to that Vermont student is still protected if the health insurance coverage is permitted under laws of Vermont. So subdivision 2 is making an exception in situations to say that legally protected health care activity doesn't apply to any kind of lawsuits or judgment or cases that's based on conduct for which an action would exist under the laws of Vermont if the course of conduct that forms the basis for liability had occurred entirely in this state. And so that's just to say, so if you had a provider who engaged in activity that was outside the scope of their license and was arguably negligent, and someone was harmed in that particular instance, and someone would, if it had all taken place here in Vermont, if somebody would be able to sue that provider for medical malpractice, that's not to be barred by this in any way. What this is trying to get at are what we'll see in a later provision of the bill is what's termed as abusive litigation, which is trying to interfere with people obtaining legally protected health care in Vermont or by a Vermont provider.
So if a person from New York goes to Bennington, assuming New York didn't have this law, goes to Bennington to have an abortion, that would be protected because she's in Vermont.
Correct.
That makes sense. And then for years before Vermont had providers to do abortion, people went to New York in the 70s to get legally protected abortions. I'm not still clear on if somebody in Vermont that statement you made, and it's not clear to me how the person would get the services if they're in another state.
Right.
And the provider, I mean, I don't think you can, would it be telehealth?
It's going to be primarily in the instance of telehealth.
Okay. So,
Yep. And so if you look at that, subdivision 3 is specifically addressing that situation.
okay, I jumped
Yep.
ahead of you then.
That's okay.
All right, so I was trying to confused about how you would get the services.
Right. So it could be that someone, comes from another state. Let's say if it was for an abortion procedure, and they came and they received services, and then they went back to their home state. But maybe they had a question or needed to have a follow-up phone call with their Vermont provider.
That makes sense.
Is that it would still protect that provider.
Yeah. And protect the provider. What about the patient?
Well, it depends, the thing is I'm sure everyone knows, is it's kind of whack-a-mole right now out with all the state laws. So like after the Dobbs decision last year, where there was no nationally recognized constitutional right to an abortion, and then leaving it to the states, is the states are going all kinds of different directions on this, and it's changing week to week, depending on what state legislatures are passing, what's being litigated, which is just about everything. And that's similarly happening on the issue of gender affirming care. So there's a number of states that have banned gender affirming care for youth and have provided. And so in both circumstances, there are situations where someone can be criminally charged, either for providing services or facilitating or helping someone else receive services. The criminal laws tend to not punish patients, but to do it more around the providers and people who facilitate and assist someone in receiving the care. But it depends on what types of laws that you're talking about. I will just say maybe, and it'll help as we go through these, because I'll give scenarios, is in the House, I was using two examples. One in the civil context, you could look to Texas, and you may have heard about SB 8. And the Texas law, what Texas did is they created a prohibition on abortion, but instead of having the state be the enforcement mechanism, they chose to try to avoid federal court review of the prohibition by allowing the public to enforce it through civil litigation. And so what can happen, according to SB 8, is that if you have someone who, let's say, either receives an illegal abortion in Texas, or maybe someone leaves Texas and they go to a state where abortion is legal and they obtain that, but someone provides them with the money to travel or gives them the transportation to travel or hooks them up with services in another state or something like that. Any person, they don't have to, the person who is filing the litigation does not have to have suffered any particular harm to themselves. It could be a family member who is suing, or it could just be a random person, and they could file civil litigation for someone violating the abortion ban for assisting someone in the receipt of abortion services. And there's essentially what's referred to as like a $10,000 penalty, like a bounty for each incident. And so that is one mechanism that's out there that's being that is out there, but there's a number of other states that are looking to model the Texas legislation. And the difference there is it has a private actor through the civil process trying to enforce the ban instead of the state, because it would come under different scrutiny if it was the state, as an actor.
Yeah, I was just a comment. It blows my mind that that they're trying to make it so that a third party who's not injured in any way can file civil suit for that. I don't really have a question. That's Didn't realize that.
So that's why if you think about, so when we're going through these definitions and the protections is that, and we don't really know how these laws are going to play out. There's just, these things are new. And so there's a lot of guessing at this stage on all sides about how things are going to evolve. And, but if you can imagine, and again, we don't know, is that, if you had somebody from Texas who came to Vermont and received an abortion. The question is could someone file an SB 8 litigation against the medical provider in Vermont who provided a legal abortion here in Vermont? And so when you see these other provisions in this bill, you see their different sections are intended to be like, that type of thing is against the public policy in Vermont. And and those services are legal here. And if you have another state trying to reach in and punish people for engaging in what is legal here, we're not going to recognize it to the extent that we're permitted to not recognize it.
So we're protecting the Vermont physician in this case,
Correct.
but not the patient.
Well, it depends. Patients are provided protection as well under this. I'm just saying that typically the legislation is less focused on
How can we
punishing.
provide protection for a Texas patient who's sued in Texas?
I'd have to go back, and somebody in the room might remember, but I don't think
think
that the patient is, I don't think the patient is the subject of it. It's
Okay,
about
it's
if
the
you, I'd have to go,
provider.
it's about if you're providing or aiding or facilitating
So
or
that's
things
the
like that.
person who drove her from
Correct.
Texas to Vermont.
Right. There's litigation right now around SB 8 where there's a number of states, attorney generals who have filed an amicus brief in a case where there's some abortion fund groups that are saying, if we provide money for someone to take a plane to a state where it's legal, are we in violation of SB 8? Like there's a lot of questions out there about how SB 8 might be used. Okay, so subdivision 3 is focusing on the telemedicine. So you see that healthcare person is duly licensed in Vermont. The healthcare provider is physically present in Vermont, and then they are legally protected as long as the service they're provided is legal here in Vermont, regardless of the patient's location or whether that healthcare provider is licensed in the state where the patient is located at the time the service is rendered. So subsection C is the definition of reproductive health care services. I think the only change to that between what's here and what was in H89 was just the removal of the reference to health insurance. All right, so now I'm going to go and move on to H89. H89.
Oh.
Because I was looking at the definitions in S37. So I'm going to skip over section 2 because I think it'll make more sense if I come back to it and refresh everybody's memories about SLAPP suits. So I'm going to move on straight to abusive litigation.
Where's that section?
So that's section 3. And you know what, we just asked, and I think they're going to start changing it so that these will have numbers and line numbers next time, because I know it is a little hard to follow through if we don't have line numbers in some of these. So this is a new chapter in Title 12, which is your court procedure. So I'm going to start with the definition of abusive litigation there. So it means litigation or other legal action to deter, prevent, sanction, or punish any person engaging in legally protected healthcare activity by, and then I'm going to go to the top of page 4. Are your page numbers the same as mine when I'm talking you through? Okay. So the first one is filing or prosecuting any action in any other state where liability, either in whole or part, is based on legally protected healthcare activity that occurred here in Vermont. And so that would be the circumstance. We would be considered abusive litigation if, Senator Sears, as you were talking about, a Vermont physician provided legally protected healthcare to someone here in Vermont. also abusive litigation for attempting to enforce any order or judgment issued in connection with any such action by any party. So trying to enforce any judgment that was received in another state. Yep.
I think I have a question. Could you share with me how this gets around the full faith and credit clause? Because that's kind of, I'm getting stuck on that, and I'm not really understanding how we avoid that problem, or maybe I'm just missing something.
No,
here.
sure. No, that's a great question. And so full faith and credit clause of the U.S. Constitution requires generally that states give recognition to the public acts and laws of other states and the judgments in other states. And that is because if you think of it in the most simplistic terms, if I have a custody arrangement, the court says I have a 50-50 split custody with my kid's dad, and that's a Vermont order here. If I could just move across the Connecticut River and say, oh, well, kids are with me now, then, there's a lot of chaos. However, there are some, it's not absolute with regard to full faith and credit. And when you're talking about recognition of other states' laws, there's more wiggle room around that, around a state to choose whether or not to apply the laws of the other state or to choose its own. And states are not required to, especially in cases where there is a real divergence in public policy, to substitute and place another state's laws in the place of their own. And so, with regard to the recognition of other laws, and you'll see as we go through this, there's a number of places where the bill states that interference with legally protected healthcare activity here in Vermont is against Vermont's stated public policy. Now, when it comes to judgments, there's really not much wiggle room there. And so you have a much stricter required adherence with regard to the judgments in other jurisdictions. And so there are a few circumstances where you don't have to recognize the judgment in another state. And that's if it was either the judgment was issued without jurisdiction, or there wasn't proper due process in the case, or if the judgment is considered penal in nature. And that one's a little a little more vague, but the example that I would use is that so like, the idea behind that is that you can't make one state execute the punishment that they have decided on. And so if you think about the SB 8 law, right, what is the purpose behind the SB 8 law? Because as you noted earlier, Senator, the person who can file the legislation doesn't actually have to have suffered any individual harm in that circumstance. It's more kind of, if there was any harm articulated, it would have to be more of a community harm. The community has decided through the passage of the legislation that abortion is not okay and therefore prohibited, but basically I think it's fairly obvious that the way that SB 8 is structured is to punish people or deter people from obtaining abortions, and then punish people for helping someone obtain an abortion. And so I think there's a strong argument that something like that could be considered penal in nature, and therefore the court might not have to recognize the judgment. But that's, it's all totally speculative, so this stuff has not percolated up through the courts yet.
I appreciate that answer. So, I'm just thinking ahead to different things that,
Sure.
If we get to mark up what we might need to add or take away. And so I'm just thinking about about that and what you just said.
Yep.
for,
And I
future.
think, if you want to, and certainly, Judge, so all the witnesses the witnesses have been tremendously helpful in the House. And Judge Joni can really talk about that a little more if you like. And then also we had a law professor who's has a lot of background in these issues on conflict of laws, especially pertaining to reproductive issues. And he was very helpful in working with us in the House as well.
And just for my notes, the three exceptions, there was improper due process, penal in nature, and what was the third one?
Issued without jurisdiction.
Thank you.
So I'm going to focus on subdivision 1B here, which is important, and this is around where the conduct occurred. Is that a lawsuit shall be considered to be based on conduct that occurred in this state if any part of the act or omission involved in the course of the conduct that formed the basis for the liability occurred or is initiated in this state. Okay, so it doesn't have to have fully occurred in this state. So that addresses the circumstances. What we were talking about is that someone comes here for services and then returns home and needs to have a follow-up conversation with the provider or something like that. It's still considered to be occurred in Vermont.
And I don't think this is, I think what's confusing to me, maybe nobody else, is there's so many parties to this that there, I was under the impression we were just talking about the person receiving the health care and the physician and maybe any healthcare professionals assisting the physician. But we're actually talking about people who might assist that person in getting to Vermont, people who might have loaned money to that person. We're talking about so many different individuals. I don't know how we protect people who never even came to Vermont.
Well, I think that
I told the story, this is almost 50 years ago. I loaned somebody $300 to help them get an abortion for their girlfriend. And I was amazed last year when I got a check for $300 from the guy. I had forgotten all about the loan, and he said, I wanted to repay you, but I can't afford the interest on the $300. And it was really, it touched me. But as I think about that, I loaned the guy $300 under the Texas law. I'd be liable.
that's the question right now. I think there's a lot of unknowns about these novel laws that are being passed to try to punish people for obtaining services outside the state.
Yeah, but how would Vermont law, assuming I was in Texas and not in Vermont, how would Vermont law protect that person who loaned the
I'm going to
$300?
show you right here, actually. That's a great
All right,
segue.
well, good,
into
good.
the-
Why are you going to show us how that's going to happen? Because, excuse me, but that sounds rather magic. And
I think the
something
issue
out of
is there are many places where people would like to provide more protections that we are not able to because of constitutional guardrails. And we'll get to some of those like around extradition, things like that. But let me move to the heart of this. So if you look at page 5, so essentially what section 7302 is doing is it's creating the ability for someone, let's say, if someone in, let's say you were, your circumstance was in Texas, right? And let's say someone then filed an SB 8 lawsuit against you for providing that $300 for someone. What 7302 does is it allows you to respond with a countersuit. This is just one of the strategies. There's other strategies later that talk about we don't issue subpoenas or summons in those types of cases. We don't cooperate with law enforcement resources in those cases. There's a number of strategies here, but this is the first one, which is basically if someone, if you see that language in subsection A talks about where I said it talks about the public policy of the state. So saying that interference with legally protected healthcare activity, whether or not under the color of law, and you'll see that term a few times in here. And when you talk about something under the color of law, it just means it has the appearance of law, the appearance of legality, but that may not necessarily be the case. And I think that that's a term that's being used more frequently because of these types of new laws in these other states that are really kind of novel, and we don't know how they're going to play out and how the courts are going to treat them. And so it's starting out with saying that, you know, interference with legally protected healthcare activity is against the public policy of Vermont. So subsection B is that any public act or record of a foreign jurisdiction that prohibits, criminalizes, sanctions, or authorize a person to bring a civil action against or otherwise interferes with someone who's a provider, a payer, or other entity that seeks, receives, causes, aids, and access to, essentially, you know, helping someone obtain those legally protected services shall be an interference with the exercise and enjoyment of the rights secured by this state and is a violation of public policy. So under C, if a person engages or attempts to engage in abusive litigation, and we go back to the definition of the examples of what would be considered abusive litigation, any aggrieved person, so it could be provider, payer, other entity, including any defendant in the abusive litigation. So Senator Sears, you would be a defendant if somebody had filed an action against you for providing that $300. May initiate a civil action for injunctive, monetary, or other appropriate relief within 6 years of the cause of action accrues. So you could have a 6-year statute of limitations. So the top of page 6, subsection D, if the court finds for the petitioner, then you can recover damages for the amount of any judgment issued in connection. So if a Texas court issued a judgment for $10,000 against you, you could countersue for that $10,000, and any other expenses, costs, or reasonable attorney's fees. Okay. So subsection E is just talking about when a court can exercise jurisdiction. There has to be personal jurisdiction. The person has commenced an action in any court in Vermont. So somebody's maybe tried to have the judgment in Texas domesticated here in Vermont so that the judgment can be enforced against you. Subsection F is similar to what we saw before in definitions, which is that if it's actionable in Vermont, so basically someone did something that was outside the scope of their practice that injured the patient or something like that, that's not what we're talking about here. Subsection G is an exception for attorneys who are just acting within the scope of their duties there. So everybody's entitled for representation. So you don't bring a countersuit against the attorney who brings a suit for somebody else. Same thing with a prosecutor. Page 7, section 7303, foreign judgments.
Sorry, before you move on, so I'm sorry if you already covered this.
That's okay.
So in 7302, somebody acting under SB 8, that third party, that would be considered tortious interference?
Yes.
Okay.
Yep.
Thank you.
I hope the Bar Association has some attorneys to provide help to these folks. If these cases ever arise, it would be, I mean, the average person wouldn't have the ability to even begin the process. I talk to so many people who, feel aggrieved, and it's sad that, they can't get an attorney to handle their case. So, this is all great on paper, but it will take some volunteer work from perhaps the Bar Association or elsewhere to get pro se. I don't think you can handle this type of case pro se, especially entanglements of foreign judgments and so forth. it's great to have it on the books, but then to try to work it through the average person.
Bob Paolini did come in on the House side, so you might want to hear from him. He helped us kind of
Bob
with the,
Paolini.
yeah, for the VBA. He helped us with that kind of exemption language.
Okay. Could you add that name,
I
Peggy, please?
I
Or
think
have we already?
I did reach out to him and I'll look up what he told me. And let you know.
So I'm going to keep moving because I know you got a lot of
Yeah.
witnesses. So section 7303 is just what we talked about around recognition of foreign judgments. It just, in subsection A, it talks about, you know, we don't give any force of effect if it was issued without jurisdiction, if it's penal in nature, or there wasn't proper due process. B is just the procedure for filing a foreign judgment here in Vermont. Section 7304 is that unless it's required by federal law, a court here in Vermont is not to order a person who's domiciled here in Vermont or found within this state, so a visitor as well, to give testimony or statement or produce documents or other things with any proceeding in a tribunal outside the state concerning abusive litigation. So, so if, let's say, lawsuit is filed in Texas, and then they want the court here in Vermont to direct someone here to give testimony in that case, this is saying we don't do that. So there's a lot of provisions in here that are talking about, and we can do this because this is not subject to full faith and credit, and we can make a choice around these things, is that there's a lot of that's in here that's like, okay, we can't control what's going on in that other jurisdiction, but we don't have to cooperate with it because it's against the public policy of our state. So subsection B is that if somehow a subpoena is issued, because there may be circumstances where it may not immediately be clear to the court that something is involving abusive litigation. So if somehow the subpoena does get issued, then the person who's the subject can move to quash it and basically say what we've been saying, which is that it's against the public policy of the state to allow or to recognize these tortious interference claims. So page 8, section 7305, choice of law is this is just stating that the laws of Vermont shall govern in any case or controversy heard here in Vermont related to legally protected healthcare activity.
Just ask them to come in and talk about the availability of pro bono attorneys that want people with this.
Section 7306 is a provision directing public agencies that in cases involving abusive litigation concerning legally protected healthcare, that public agencies are not to cooperate either through the provision of use of time, money, resources, facilities, things like that. In the circumstances for, you'll see in the subdivisions, the provision seeking or receipt of or inquiring about legally protected healthcare activity, or assisting any person who's receiving that care. So subsection B, bottom of the page, it starts, and then the part of it's at the top of page 9. It doesn't apply, the non-cooperation directive doesn't apply in any investigation or proceeding where the conduct subject to potential liability would be subject to liability in Vermont. So again, if it would be legal here, then it doesn't bar cooperation. It doesn't apply to any action taken by the judicial branch in any judicial proceedings, because obviously the judicial branch is going to have to be sorting all this mess. And then the third one is it doesn't apply to a public agency or an employee who in the normal course of business is responding to a warrant or extradition demand on the good faith belief that the warrant or demand is valid. And so that could be that you have a law enforcement officer who gets, you know, a warrant and there to serve the warrant, and it may not be because of the information that's contained or whatever, it may not be evident to that law enforcement officer that it's related to abusive litigation. And so, so if they serve that warrant and then it's later determined that it is abusive litigation, there's no liability on that part of that officer as long as they're acting in good faith on the information that they have. The next section, section 4, is freedom of access to clinics. This is based on the federal legislation. I think Congress adopted it in '94. And so the federal one provides for criminal penalties for interference with access to a clinic. This is just a civil ticket. So it provides another avenue to respond to interference at clinics that wouldn't be criminal. So there are other places in law currently, whether it's disorderly conduct or something around damaging property, that could be addressed in a criminal context, but this is a civil ticket. Subsection A just kind of sets forth the General Assembly's findings and policy around that everyone has to be able to access healthcare facilities for the purpose of obtaining legally protected healthcare, and the exercise of a person's right to protest or counsel against certain medical procedures has to be balanced against another person's right to obtain those legally protected healthcare services. So looking at page 10, you'll see the definitions in subsection B. Bottom of the page, subsection C, no person shall by force or threat of force or by physical obstruction knowingly injure, intimidate, or interfere with, or attempt to do those things with another person because the other person was or is obtaining or providing legally protected health care. And then the other elements of that could be on top of page 11, no person shall knowingly damage the property of a healthcare facility because that facility provides legally protected health care. You'll see in subsection D, it's a $300, not more than $300 civil ticket. So that's a Judicial Bureau offense.
Is legally protected healthcare just those two items that it defines?
Yes.
So if someone's seeking other healthcare.
Well, I think they could be,
I mean,
as I mentioned, they could be prosecuted under the other
Let's
ones.
say if there's, there's strike or whatever you want to call it, protest aimed at a particular facility like an emergency room in Brattleboro, and somebody needs to go in to get their dislocated shoulder fixed, and they can't get in there. Isn't that also? How does that get? I mean, I think we should be able to get anything. The protesters shouldn't be able to.
I hear your point, and that was discussed in the House as well. I think probably when you hear from the state's attorneys and the Defender General's office, they can talk to you about the existing provisions in law that address these scenarios. I think the reason the House chose to include this was because there is a federal act, and that these two, the facilities that provide these two types of services tend to be the ones that are more likely to have people protesting at them. But it's certainly a policy decision for you. You could choose to expand this if you want to.
No, I think if the facility provides care, then anybody should not be restricted from getting their care. Other than those, I'll listen to that's a question for me. Why, maybe the state's attorneys have. And then I would ask state attorneys, well, if that's true, then why isn't this protected already under current law?
I think it is, depending on the type of conduct, and there are other statutes that can cover it. I think what the decision.
What I worry about is when you specifically name two procedures or two forms of healthcare. I shouldn't say procedures. Two forms of healthcare to the exclusion of all the others, and then you say, well, there's another law that takes care of that. I really worry about confusion in the system of what did the legislature mean, and I can see the Vermont Supreme Court saying the legislature should have been clear that, you know, Sears wasn't protected to get in to get his shoulder fixed. It was only this, that's what the legislature meant. And I've seen too many of those where, you know, it defies logic that they would come up with that. No offense to the Supreme Court, but it does defy logic sometimes. But it happens. I've seen it in too many cases.
Well, I too am looking for that answer, to your question, because it appears as though the right to assemble would be challenged, and we would be more or less looking at, can we pick and choose when they can assemble, when they can't assemble? So I'll be interested to see what our attorneys have to say on that also.
So this language is based on the federal act, which has been upheld by a number of times by federal courts.
Based on what? I'm sorry, what are you telling me?
That I'm just letting you know that the language has been vetted by federal courts around the balancing between protecting people's access to healthcare facilities and people's right to express their opinions, and the language
I'm
has
not
been
against
upheld.
this bill, by the way. I sponsored one of the Senate bills, so I'm not against this. I'm all for it. I'm just worried about certain provisions as I see them. I think I have to say that publicly because you never know what's coming out over YouTube.
Is it okay to keep going?
Yeah.
Okay, so section 5 is just adding the civil tickets in section 4 to the jurisdiction of Judicial Bureau. Section 6 deals with extradition. So extradition is one of those areas where there's not a lot of discretion for states. So there's a provision, there's the extradition clause in the US Constitution. There's also federal statute around extradition. Vermont is part of an extradition compact with other states. And generally, if you have someone who has allegedly committed a criminal offense in another state, and then the governor of that state issues a extradition demand, and that is sent to the governor here in our state, is that as long as everything is in order and in compliance with the way that they do that, then we are required to extradite that person back to the demanding state. There is
Good. I'm only smiling because, you know, it was the one of the MSNBC programs fully explained extradition in the Trump case between New York and Florida on my way home last week. So
great.
I got really expert in
Fabulous.
extradition.
That's good. Well, I will buzz through this section quickly then.
I missed that MSNBC piece.
Yeah, I mean, it's really a good explanation. You know, he won't get arrested because he's not in New York. He'll be willingly or could be extradited to New York.
Right.
Or he would have to.
Right. So, so what this is saying is that where we do have some room to make a choice of whether to extradite, the legislature here in this section is saying we don't want the governor to extradite in this one particular circumstance where we have the ability to choose. And that is, you'll see at the bottom of the page, the governor shall not surrender a person charged in another state as a result of engaging in legally protected health care unless the executive authority of the demanding state alleges in writing that the accused was physically present in the demanding state at the time of the commission of the alleged offense, and then thereafter fled the jurisdiction. So if you remember back to our definition of legally protected healthcare, we're always saying the healthcare provider was licensed in Vermont and physically present in Vermont when they provided services, right? And so these two work together. So in order to say we're not going to extradite someone, they would have had to have been in the other state at the time of the commission of the alleged offense, and then essentially left the state trying to kind of flee the jurisdiction. So this means that, and this was something that, people in the House were like, can't we do this? And I think myself and the other witnesses were agreed that you couldn't. And so if you had someone perhaps in another state who was a resident of that state, abortion was not legal in that state, and they then obtained an illegal abortion in that state, and then came to Vermont, to stay with family or something like that, we would have to extradite that person back to that state. Okay, next is regarding issuance of summons for a person charged criminally. So this is kind of similar to what we saw in the civil context earlier. So new section in Title 13. Again, subsection A just stating the policy of Vermont and how we view interference with legally protected health care. So you see subsection B is a court shall not issue a summons where prosecution is pending in another state concerning legally protected health care activity, or where a grand jury investigation has commenced. And then the last section on page 13, and then it goes through the rest of the bill. So you are probably familiar with Vermont has what's referred to as Safe at Home program. It's an address confidentiality program within the Secretary of State's office that allows survivors of domestic and sexual violence, I believe in stalking and human trafficking, to register with the Secretary of State's office to have a separate address where they can receive mailing and have like an official address with the state if they are concerned about their safety. And this is adding folks who are either providers, patients, or maybe volunteers regarding legally protected healthcare activity to be able to avail themselves of the Safe at Home program. And we worked with the Secretary of State's office on the language with that. And so they would be able to register. So if you had someone, there are a few other states that have this. I think New York has it, Massachusetts has it, whether it's really works. Is there any confidentiality or privacy in Vermont in such a small rural state? But if you had, let's say, a provider who was providing abortion services or gender affirming care, and they, had maybe been subject to some harassment or things like that, oftentimes stuff comes from, not from Vermont, but things gets on the internet, that sort of thing, and people become targets that they could avail themselves of the address confidentiality program. Pardon? Maybe you should get on there? Is that what you said?
No, I just, just some of the recent emails, I don't know where this is coming from, but really vicious emails are starting to arrive in my box.
Well, Lauren Hibbert can talk to you about that program. She's who we work for, the Deputy Secretary of State. And so I don't know if she.
Senator.
And this may actually be a question for Lauren, because this is something I've brought up repeatedly, just for safety of providers, the fact that we publicly put their information out there. Do you know if there's a legal reason why we wouldn't just make all of those addresses confidential?
All of the.
So rather than say, like, if you can prove that you've been harassed, then
Oh, no, you don't have to prove it, actually. There's not a point of that. I'm just saying anybody can get on it. You don't have to, there's no barrier there. So let me show you. It's just if you, so you can see the language there it's who can qualify. And then that was just my assertion as to why somebody might be on there.
Yeah, I guess and I'll talk to Lauren about this. I guess I wonder why we don't just make the entire list of providers' home addresses confidential rather than asking them to go through a step to ask that it be confidential.
So, yeah, I don't know, I may be talking to the network as well about that, because we worked with them on this and as well as Planned Parenthood, and just kind of thinking about who might want to avail themselves, and how many people might want to avail themselves of the opportunity.
I know this has come up to me with constituents and friends in the mental health field, particularly when they moved away from having a physical office space and only did telehealth from a home office. And you have to put an office on your
Oh,
OPR
right.
forms, and then that's put out.
So you're talking
publicly.
about in terms of registering
Yeah.
for OPR purposes.
Yeah, so
right?
this sort of sparked that bigger, broader conversation about why aren't we making this kind of stuff just confidential rather than sort of opting in to that.
Right.
And certainly from my own experience of just not knowing that you would need that to be confidential. When I ran for office, the first time I used my home address, and then I had a stalker the second time and had to switch to a PO box, but my address is still out there because I didn't think until something bad happened that I shouldn't have my address out there. And I want to be really thoughtful about how we're protecting people and not asking them to wait for something bad to happen to make them think about that. So,
Right.
Anyways, I digress.
No, it's actually an important point. Published my whole number because of the harassing calls my wife would get while I'm up here. It got absurd.
But we often don't think about the problem until there is a problem.
So the final is just the effective date. And so the act takes effect on passage with the exception of the address confidentiality program, which would be September of this year, just to allow the Secretary of State's office to have the time to update their forms and get everything ready.
Do we have the Secretary of State on our witness list? Peggy? Probably here, but who is it?
Lauren Hibbert. She's
Lauren.
the Deputy Secretary of State.
And she used
And
to be
she's
the
to be
director of
OPR.
OPR, so she's got lots of good information.
Anything else, Michelle, or any other questions from Michelle? Senator Norris.
I do have one or two, actually, yes, thank you.
Sorry, I turned my screen off.
That's all right, I'm sure you know these answers anyway, Michelle. Are you familiar with any other states that have similar laws to H-89 and S-37?
There are a number. So what happened after the Dobbs decision, or really kind of the leak of the Dobbs decision, then some states that were still in session, which weren't really that many, because Dobbs came down in June. I didn't remember when the leak was, maybe late April, early May. A number of states started passing pieces of this. And so it wasn't necessarily like one big package, like the way that if you put 89 and S-37 together. I can come up with a list. It's always changing, but there Massachusetts, New York, Connecticut, New Jersey, California, but I'd have to kind of do a little research to kind of see who's got what right now, because like I said, it's been sometimes, and then for a number of states did things through executive order, so that if they had broader executive order authority than we have here in Vermont. So there were a number of states, I think New York being one of them, that did a number of these things that were in either of the two bills and did it through executive order rather than through legislative process. But there are a number.
So there's a number of states who have certain sections of this bill that are similar to.
Yeah, Massachusetts, what we used for, like, if you took our two bills together, we used Massachusetts. They had a piece of legislation that they passed last summer that had all of it in one piece of legislation.
So that's good, I guess, because
We're
I don't
definitely
know.
not, we're kind of at the forefront, but there's a number of big states that are ahead of us on it.
Just don't want Vermont to be the clearinghouse for these activities, because I guess my next question is, who are we trying to protect in this bill, H-89? doctors, patients, everybody, who are we trying to protect?
I think what, and some of the witnesses might do a better job of this than me, but I think what it's trying to do is to protect people either receiving or providing services or helping people obtain services, these services that are legal here in Vermont, from extraterritorial application of other states' laws, right? So this is a new area where, like, generally, so let me give you an example, is that, so gambling is legal in Nevada, right? It's not legal here, or I guess maybe some things are, I don't know, but, or it will be, but.
Casino gambling.
Right.
Might be a better way.
Right, casino gambling, right? So if you go to Vegas for the weekend and you gamble, Vermont doesn't try to prosecute you or the casino in Las Vegas or anybody associated with that for the fact that you left Vermont and went to a state where casino gambling was legal and engaged in that activity and then returned to Vermont. It's kind of this, it's the similar kind of concept, right?
But yet if I come back with my $1 million, they're gonna tax me on that, or, because if I go buy an ATV over in New Hampshire, they want me to claim that on my.
I don't know. I have to talk to another lawyer about the tax
No,
stuff. I'm not
full-fledged.
sure about
Yeah, I
that.
think the answer is yes.
Yeah.
But
So I
they're
guess-
not gonna send you to jail. for
They're
this.
not gonna initiate civil litigation or criminal, or a criminal indictment against you.
So I guess my next concern, and do you see that there could be any associated cost to Vermont residents on this pretty
But-
exclusive bill?
Again, it's only intended to be a response to an action that comes from outside. Like, it's not creating new causes of action or new costs for Vermont to do things. In terms of what the cost might be, you know, maybe a cost with regard to the address confidentiality program, but I don't recall them ever asking for an appropriation or anything like that. So, you know, I would talk to Ms. Hibbert about that.
So I have one final question for you.
Sure.
So in the discussions here, we had mentioned, you know, attorneys free of charge, pro bono, and so on and so forth. So
Mhm.
if we're already anticipating that charge, and if we're dealing with, I don't know, indigent people coming from, I guess, anywhere they want to come from, and they can't afford these medical services, are they going to be provided those medical services? And if so, who's going to absorb those charges?
You mean outside the legal context, if someone wants to come from another state and obtain legal services here in Vermont? That's kind of outside my area about how healthcare is provided to people.
So maybe give me a suggestion as to whose area it is in, so I can ask that.
You talk to Ameren. I mean, are you talking about if someone moves from another state, moves to Vermont, and then,
Someone just comes from out of state to obtain these services.
okay, you're talking about whether they will
They can't afford
qualify
them.
for Medicaid under Vermont law? Or
Right.
is that what they're
Right.
looking at, who's gonna pay for their
Exactly.
healthcare expenses? I would talk to Ameren about that. I don't know about in terms of how healthcare and Medicaid costs work.
It's magic.
It's far from magic.
No, I mean, you know, on Medicare, you probably get, your monthly report, and then MVP sends me a report. This is not a bill, but this is what they charge. This is what MVP paid. Or this is what Medicare paid. You know, they charged you $20,000. Medicaid paid $18. You owe blah, blah, blah. It's all magic. Who can figure out why, you charged $18,000 and only got $200 from the two insurance agencies?
I hear you.
Medicare and the other.
But this bill does nothing to change the
No.
billing
It
system.
doesn't
or-
change that.
Right.
It's not-
Correct, I mean,
No.
we could
That's what I
argue we
meant by-
should.
That's what I meant by magic.
Got it.
It's all magic.
It's all magic.
Nobody could have figured out system.
Well, that's because it's a mess. I think every other country in the world has figured out a better system, but that's a different conversation.
But S-37 dealt with coverage and Medicaid coverage and insurance coverage and things like that. So you can speak with Amron about that.
My concern is not how they bill. Is, are we absorbing any additional cost as from us as taxpayers? That's my concern.
Or could we? And we'll talk to Amber
Yeah,
about that, I guess.
I do not see anything like that in this bill. Whether or not, what type of court resources it might take up, you know, you can talk to the Zone about, but I don't recall there being any testimony.
on my list.
Okay, I don't recall there being, you know, any testimony from any of the witnesses about this having a fiscal impact.
Thank you.
Thank you, Michelle.
Sure.
Appreciate it. We're gonna hear from Charity Clark, our Attorney General. Take a break. Thank you for coming over, busy schedule,
It's
but it sounds like
pleasure.
you might have a lot of work to do if this passes. Then again, maybe not.
Maybe not. Well, it's our pleasure to, for the record, Charity Clark, Attorney General. I also want to introduce Ellis Spotswood, the Solicitor General, who I brought over as our subject matter expert. But we are pleased to be here because we heartily support this bill and feel like it's in great shape. It has arrived to your committee having gone through, I would probably many months of work. We have had more than one opportunity to weigh in on that. All of our recommendations or feedback have been incorporated. We have no concerns about the bill and feel strongly that it should pass. I know you've already received a fulsome overview and walkthrough of the bill, so I don't feel like I need to walk through what's already been covered. So that's why I'm being so straight to the point this morning.
Well, no, it's refreshing.
Okay, good. Yeah, I mean, I could say stuff, but why bother? Maybe I'll just add by saying that several components of this bill were measures I advocated for shortly after the Dobbs decision was announced. And I'm very pleased to see those measures incorporated. I know Senator Baruth isn't here, but stood with me at a press conference last June or July and delineated those points. So just really happy that these months later, we've arrived at a point where it's in this committee in such good shape.
You don't see anything in here that would inhibit the Attorney General's ability to protect women's right or gender affirming rights, or people that might aid that woman from another state coming to Vermont.
No, I don't. I mean, like I said, we've incorporated any of those concerns. We provide that feedback, and all the concerns we had are reflected in the current draft.
Senator Ball.
Oh, no, I'm just sitting with my hand up. I don't actually have a
Oh,
question, but
okay.
thank you. That's just the way I'm sitting at this moment.
And by the way, welcome to Senate Judiciary. This is the first time you've been here this year.
Yes,
And
you're right.
welcome to our new Attorney General.
Thank
We've
you.
all met you out and about one way or another, but
I think so. Yeah,
well for that. So congratulations.
thank you, and
I know it's
congratulations.
a little bit late. Here we are in March, but
No, I appreciate it. And what a great auspicious bill to be here
yeah.
talking about.
Are there any questions about the bill for either the Attorney General or, and I'm sorry, I forgot your name already.
That's all right. It's Ellis Spotswood. I'm the Solicitor General and resident reproductive rights.
We did have some questions. If you had a situation where you had a protest going on, there's language in the bill about it, and it was at a hospital, and somebody needed to get into that hospital in order to get their shoulder looked at. in the emergency room, but not one of the two protected cases here. Seems to signal that that wouldn't be protected, but the gender affirming or the reproductive is in the bill. So how would that person who wanted to go in to get their dislocated shoulder put back together, and they were denied entrance, do they have some other recourse?
I don't have a lot of concern about that, but, you know, I didn't bring that expert today. I brought Ella instead.
We're gonna, I mean, I was particularly concerned about that provision because I've seen in the past where this, and I think the state's attorneys may have some answers to that as well, but I've seen in the past where I read a Vermont Supreme Court decision where they said the legislature wasn't clear on their intent, and they only intended to protect the person who was seeking gender affirming care or reproductive care and not care for their broken shoulder or dislocated shoulder.
Why don't I, oh, sorry, Senator.
Oh, no, well, I was just gonna respond actually to what you're saying real quick. I think from what I'm reading is that because the section that you're talking about has to do with assembly and freedom of speech, you know, whatever we do that could affect that, it has to be very specific or narrowly tailored in order to allow us to do that. So I think perhaps that's why it's so specific in this section, but I think the attorneys might definitely know more than me.
Well, we'll wait there.
I was gonna say, I'm sure the state's attorneys can address this, but I'll also just speak with our criminal chief about this and see if she has it. She's very insightful, and see if she has any insights, and I'll email Peggy and for follow up.
Great. Well, thanks so much for being here.
Yeah,
Appreciate
our
it.
pleasure. Thanks for
Glad to
having us.
hear that everything in here was incorporated.
Yep.
And as we go through markup, if you would kind of follow with us, so that I don't want to upset one of the sections that you worked hard on by us, you know, changing it or removing it.
Perfect.
At least let us know what impact that might have.
That's great.
Or we may just rubber stamp it. But we rarely do that.
All right. Well, thank you very much.
Thank you. Thank you. I'm going to take a brief break.
What time?
Until the clock gets to 8.